Good morning, respected dignitaries, our beloved principal, young and dynamic Dr. Srinivas Kumar, Sir, Head of the Departments, and my dear student. This is Dr. Pawan Sai, Head of the Department Mechanical Engineering and IIC President at Srinivasa Institute of Engineering and Technology. I extend a warm welcome to all of you. Today we have special program on intellectual property rights focusing on patent and design filing. We are privileged to have the Rajiv Gandhi National Institute of Intellectual Property Management partner with our organization under the National Intellectual Property Awareness Mission. Srinivasa Institute of Engineering and Technology was established in the year 2009 by Sri Saraswati Education Society. The institute is approved by AICT New Delhi and permanently affiliated to JNTU Kakinada. The Srinivasa Institute of Engineering and Technology boasts a beautiful campus with wide pathways, impressive buildings, and spacious playground nestled near Amlapuram, in the heart of the Konaseema, Andhra Pradesh. It is popular choice for the students seeking a quality engineering education. The institute has a strong reputation for excellence, offering BTech, MTech, and Diploma program. Now, I handle this session to the today's guest, Dr. Bharat N. Suryavanshi, Assistant Controller of Patent and Design. Thank you.
That again, the idea is coming to improve devices from your mind. Therefore, again, a device what you are claiming is a product of mind, that is intellectual property. You might have going to the petrol pumps. Day by day, rates are getting higher. So somebody among you is trying to give, or any chemical engineer is thinking to give biodiesel as an alternative solution for petrol and diesel. As we know, petrol and diesel are not renewable source of energy. So somebody is giving alternative solution, that is biodiesel. What is it again? Intellectual property arises from your intellectual's mind. Therefore, the product of mind is called intellectual property. Or you are writing some new book on thermodynamics. Again, the idea to write the book is generating from your mind. Therefore, again, it's an intellectual property in the form of copyright. Apple laptop is there, Apple mobile. The design of that was generated from someone's mind or came from someone's mind, though it's a form of design. So any kind of idea that arises from your mind is called intellectual property. How that property arises? When you are in the classroom with your professor or students, or you are in the laboratory carrying out some research, or sitting alone or in a group of people and trying to solve that problem. The solution, what is ultimate idea from your mind, is an intellectual property. For example, did you know one of the company has developed smart shoes? Why can't Bata, Puma, Adidas, why they are not developed? Because they have not got idea. So someone has invented, that is Austrian company. Why they have invented? Because there was a problem in the public domain for the blind people, as they cannot walk easily on the road. Therefore, they have make use of ultrasonic sensor, wherein they are able to detect the obstacles on their way up to 4 meters away, how long distance, so easily they can walk. Great invention for the blind people. So there are many topics yet to be touched in mechanical, in electrical, mechanical, civil. So you can go for that and you can get patent for your technology. See, one of the professor from Nagpur has developed cold drinks from mova flowers. Earlier, these flowers were known for only production of liquor, but he has produced cold drinks. What is it again? New idea in the mind of Dr. P.C. Again, intellectual property. Mobile came, but there is no Bluetooth. Geoff Hudson has invented. Mobile came, but there is no front-facing camera. We never used to take the selfies. Now we are taking selfies. What is that? Again, invention. Front-facing camera and maximum display. What is that again? Invention. Idea. Day by day, we are trying to go ahead in the technology, trying to meet requirements of ours in the form of medicine, devices, machines, all the field, we are getting that. So all these are examples of technology. We can get patent for that. Method and apparatus for authenticating biometric scanner. It is combination of hardware and software. Therefore, you can get patent for that. Only if you are claiming software as such, you are supposed to go for the copyright. The small clip, shoes, bags, these are a simple example of inventions. Let us see what is the background of intellectual property. Property means your mind directly goes to the tangible form of property. You say, I'm having car, gold, plot, flat, even land in my native, so I'm rich enough. There is another kind of intellectual property which is intangible form of property that we cannot touch. That's an industrial property and copyright, wherein different kind of properties are these patents, trademark, design, GI, layout of circuit, protection of plant varieties, and trade secret. Let us see one by one. What is IP? I told you product of mind, but how to define that? Intangible creations of human intellect having commercial value, asset like any other form of property. That is, IP is called as an exclusive right. Somebody filing patent from your college, the right is with them, not with their spouse or children. Only applicant or the person who is on the right, they can exercise the power of that. Therefore, we can say IP is also a negative right. Again, it's an territorial right. Once you are applying for the patent in India, it's valid only in the country of India. You cannot claim your right in USA, Japan, Germany. If you want to claim there also, you are supposed to file your application in those countries also by means of two way. One is called PCT, another is called Convention Application as per section 135 of the Patent Act. Again, IP is an licensable right. If you are developing any device like machine or any car, Hyundai company develop some new car with a new design, then they can assign the right or license to any other company like Maruti Suzuki or Mahindra or any company where they want to get more money out of that by licensing. What is patent? Exclusive, monopoly privilege or right granted by the government to the patentee for 20 years from the rate of filing or priority for commercial gain when you are disclosing everything clearly then only. Otherwise, you cannot get because many people are developing devices process but they never clearly define that. No drawings are clearly given. No claims are clearly made. No detailed examples are given. Therefore, we reject that. Therefore, while writing, you write clearly, then you are getting right for 20 years from the government of India, that is patent. You are doing project in the B, MTech also, doing research in PhDs. While doing your research or a project, you can file the patent. But you don't know whether your research topic or project topic is going toward the inventions or discoveries. So discovery means finding or exploring something which is already there in the nature. And discovery as such, no technical effort. You know rubber, but from that you are using your mind, using your technology, you are making tire from that, which is an useful article. What is it again? Invention. So we should understand whether your research topic is qualifying the definition of invention or not. If it is invention, it may be a new product or process. ATM machine, it's a product. Earlier, before 2003, it was not there. CT scan machine, earlier not there. Process of making beverages, process of making medicine is again product. Fridge is a product. Bulb is a product. Fan is a product. Cement compression is a product. So it should be product or process. We should be useful to all. Something novel, non-obvious, and should not be in the public knowledge before the filing date. Then definitely we can say your research topic is qualifying the definition of invention. You can file the patent. But granting of the patent is respect to section 3 and 4 of the Patent Act, wherein it relates to non-patentable inventions. Simple example, sharpener. Earlier when I was student, I was not having sharpener. I used to use the blade, but someone has invented. First time who brought the technology and they get the patent, they are called inventor. Your professor, you may be the doctorate, awarded many PhDs, but you are not inventor until unless you file the patent and you have got the award of that. Therefore, we know who has invented aeroplane, who has invented electric bulb. All we know we are studying the school level. Again, this telephone. From this example, I want to convey one message. Therefore, I have taken this. You can think this device was there since 1876. We have seen in the old movies also. If I want to dial 10 times, I dial. If I want to take it to my principal cabin or HOD's cabin, I cannot take because it's connected to a particular point. So these are the two drawbacks of this telephone. To solve this drawback, the scientific community or directly you can say the people of electronic and telecommunication thought of bringing this table phone. Wherein I can dial 1 2 3 4 easily or whatever the mobile number easily because numbers are there, buttons are there. But I cannot change again from my cabin to my HOD's cabin or my dean's cabin. To solve that problem, we got cordless phone, which is long. We can take in the hall, kitchen, drawing room. But I cannot take in the meeting, nor in the car, nor in the train, nor in the plane. To solve that problem, we got the mobile phone in India in the year 2002 or in and around that. If you remember, simple Nokia was there, silver color, very heavy, and only incoming and outgoing were there. Now we got video calling facility. We got Google Meet, Zoom Meet, WebEx. What is that again? Improvement of technology from AGable to mobile phone. So from this example, I want to make you understand that getting patent is not difficult. Even if you are improving your machines, devices, instrument, compositions, process, you can get patent for that also. I'll quote another example to make you more understand. I am from civil engineering background. There are many cements are available in the public, but I am developing improved cement composition comprising gypsum of so and so percentage, which enhance the taste, which enhance the strengthness of that. So what is that? So I'm making improved cement. So if I'm able to show in my examples that my cement is good quality than the other cement, if you are proving, definitely can get patent for improved cement composition. So improvement in the technology, you can get patent for that. Nano car is an example of invention or technology. Drones, smart card are the examples of invention and technology. Let us see another kind of intellectual property called design. What is design? You know, shape, configuration, pattern, ornament, or composition of line. Simple iron box of Bajaj. You can check my two glass. Both the designs are different. You can check my water drinking jug. You can check your jug. The designs are different. Anything which looks beautiful, that's called design. Flash design, mobile, brush design. Car, even mechanical engineer, you know, even handle design is also different. Mere functional or technical feature of the article are not considered design. Term is 10 years. You can extend for 5 years. Total 15 years term for the designs. You can see beautiful cup set, new design. This sanitizing machine, new design. See all the ampoules, injections, medicine, all the designs are different. Textile design, curtain design, bed sheet, earrings, bangles, all the designs. See my watch simple. You might have some other company where the design is different. See, you are having different combs, wallets, water bottles. My comb is in this fashion. No new design. Pen, pencil, all the designs are different. You may be going to the parties when you are score more marks or birthday occasions. You are taking Coca-Cola, Maaza, Sprite, many cold drinks. But you touch your heart and say, have you ever thought why Coca-Cola bottle design is like that? Why Sprite bottle is like this? Why Bisler is like that? Why Aqua fine water is like that? Why rainwater bottle is like that? It never come to your mind because you never think innovatively. If you are thinking innovatively, definitely you can achieve something. See, new designs and surface pattern. You know sharpener, but dual in nature. You know pencil, peacock and parrot. So anything which looks beautiful, that's called design. See. This design was developed by one of the students. You are also doing project, but what you are doing? You are going to the libraries, copying the senior thesis, and just mere change in the data and submitting to get a degree. It's not an innovative work. If you want to really do innovative work, you can do something new. So definitely, this design was developed for the coolie people who are working in the construction company. As you know, they are carrying out stone, bricks, sand, cement directly on the head. So they are having neurological disorders, back pain, disorder. To solve that problem, he has brought this design wherein it's not on the head, it is having some gap. Most of the weight is sort of again distribution of weight throughout the body. So we can keep away from such kind of diseases. Another kind of intellectual property called semiconductor integrated circuit layout design. You know what it is, or electric people are knowing what the circuits are. If these are new, you can go further in the government of India. You are having term is 10 years. Earlier we used to use China chips, Taiwan chips in many of the hardware devices. If you are new, you can go for the registry in the government of India. You know what is trademark or brand. Tata, Bata, Reliance, Bajaj, Wipro. The name of the company which advertises that it's a word, name or color combination to indicate the source of the company. See, R with encircled is a registered trademark you might have seen many products like telephone, mobile, Apple, all. TM means you applied for the mark it to get permission from the government of India. Once you got, then you can use this one. Otherwise, you can see many water bottles they are written TM only because it to get permission from the government of India. Duration is 10 years. It can be renewed every 10 years, subject to the uses like Tata, Bata, how long they're in the market. There are different trademarks, collective marks, certification marks, slogans, shapes like Adidas, Dil Mange More. All these are different kind of trademarks. Another kind of intellectual property called geographical indication. Place name used to identify source of origin, quality, reputation, or other concepts like Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra petha, Nagpur oranges. Term is 10 years. It can be renewed every 10 years subject to the usage. See, these are the different kind of GI products. Let us see another kind of intellectual property called copyright. Copyright is an bundle of rights. It restricts unauthorized copying and reproduction of an original expression, literary work, movie, music, printing, software. The term is life of the author plus 60 years. Therefore, you might have heard many singers are no more, but still they are getting royalty for their songs. Many authors written the book, they are no more, but still they are getting royalty for their books also. If it is literary works, if you are writing books, novel, story, autobiography, manual, poem, anything, even thesis, you can get protection under section 2 of the Act. If you are doing artistic work under section 2C. If you are in drama, 2H. Musical works, 2P. Sound recordings, 2XX. Cinematograph films under section 2F. So each kind of work you are getting registered in the government of India. Therefore, no one can copy. Let us see another kind of intellectual property called trade secret. Some invention, data, information cannot be protected by means of patent design trademark. They are supposed to keep as a trade secret. Like idea if you are having, any survey method if you are having, manufacturing process if you are having, experimental results if any, chemical formula if any, recipe of any food products, financial strategy, client database, anything among this. If you want to keep it a secret, you can. Like Coca-Cola, this pizza recipe, this again, what is the KFC chicken recipe, content of Coca-Cola, Mazda, all got different secrets. So you can also keep secret if you want, or if you want to disclose, you can take formulation and so and so. It is left to you. Even you are able to protect your plant varieties, seed varieties also as Jaya, Pusha, Padma, Basmati rice, Kala Moch, many more. But you cannot get under the Patent Design Trademark Act. You can dealt separately under the Protection of Plant Varieties and Farmers' Right Act. The term is 15 years for annual crops, 18 years for trees and vines. Therefore, day by day we are getting improved varieties of the many of the plant and fruit varieties, even seed varieties also. I have taken simple example to make you understand how we can protect single device with more than one IPR. Listen, by knowing this symbol, we can say it's an Apple company because known trademark, well known. Overall design of this. Apple sign in that. User manual is an instruction. Layout of circuit. So all these are different, but they got patent by single product like in Apple company. So that other company like Dell or Samsung never copy patent of Apple, design of Apple, trademark of Apple, copyright of Apple, or circuit of Apple, because they got all, so that only one player in the market to the Apple is only Apple company. So we can say it's an power of intellectual property. No one is the competitor of him. I've taken another example to make you understand. Formulation of Coke. What is inside this bottle? We don't know. That is trade secret. Coca-Cola in this fashion is a trademark, you might know it. Bottle design, small, increase in size, again small, again. Then design of this bottle. You can check other bottles. Patents can be obtained in respect of bottling equipment. Machine from which I am making the bottle, I can get patent for that. Copyright in the short database, text, all we can get product. You see, single product but got patent, design, trademark. Therefore, no one can copy this technology nor design nor copyright of this. Like Mazar Sprite or soda also. You can check simple example again. Mobile you can have no Motorola, Nokia, Apple, Samsung, many mobiles. You can check all the designs, trademark, even the technology also differ. Therefore, each playing in the market, they are having their own. Whatever the client want to buy, they are buying. If you want to buy Apple, paying the more money. If you have to Motorola, 16 to 25,000. So, whatever the price in your range, you are buying that. No one can copy the technology. It's the, again, we can say power of IP, or we can say it's a very important aspect to get a patent, design, trademark to your product or process. Let us see what are the career opportunity for students who are listening my lecture. If you want to come in the government of India as an examiner of patent and design, you should have qualification as MSc Chemistry, Biotech, Microbiology, Physics, or any branch of BE. Means you are eligible for that, mechanical engineering eligible. We advertise the post in 2, 3, 12, 16, 18, 19, even recently in 2023, we have given advertising for the post. Now we are filling the post. If you want to come as an examiner of trademark, GI, copyright, you should have a law background. Then those people are eligible for that. Again, if you want to work as a patent agent, any science graduate, BSc, BCA, BE, BDS, MBBS, any science graduate can apply for the patent agent examination. There are two papers. One is objective, other descriptive. If you qualify, then definitely you are getting patent agent number from the government of India and you can practice it. Or you can work in the litigations. Many of as an GRF and SRF patent fixing centers. You can work in the IPR cell, IPR policy of central government, state government, many MNC companies, or you can work in the NGOs also. There are many IPR firms in Chennai, Kolkata, Delhi, Mumbai, Madras, many big places. You can work with the IPR firm also if you are having the intellectual property knowledge. As I told you, you may be scientist, professor, faculty, students. You are not called as an inventor until and unless you solve some problem or do something new. So how we can become inventor? By simple approach. While carrying out research or a project, identify some problem, solve that problem, you can apply for the patent. For example, I'm taking a very simple example. We are using different shampoo to take our head bath. Somebody using Vatika, Sunslick, Doe, Mamaearth. Recently, some people are using Wow shampoo. Why you are using this shampoo being a scientist or being in this? Someone is using, so simply you are using. Some heroines are using, so we are using. There is no fact at all. So somebody among you also is developing an improved or herbal shampoo composition for treatment of dandruff, and if you are able to show good results and more efficacy, then definitely your shampoo, that is, you can get patent for that and you can come with the manufacturing also and can become owner of that company. So any problem you solve, you can. For example, I am having computer background, physical mosquito catching bat. I'm being in that field, I want to develop digital mosquito catching bat. Again, new technology, new invention. So any problem, if you solve, you can get patent. There is no herbal medicine for the cancer. We are taking allopathic chemotherapy. So somebody is developing herbal medicine cancer. They again problem solution. Nanocar was not there. Somebody has invented in 2019. What is it again? Invention or technology. So if you solve any problem, you can file the patent application. You learned what are the different kind of intellectual property, how to convert your research into an invention, and you can check whether it is applicable to section 3 and 4. If not, you can go for the patent filing. Let us see how to file patent in India and who can file. Any person, startup, MSME, anyone can file. There is no age bar limit or education limit to file the patent application. You can file offline or online. For offline, you have to visit to your center. For example, you are from Chennai, then your center is Chennai only. If Telangana, Karnataka, they have to come to Chennai to file the patent application. And if you want to file online, you can file the online. See, Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Union Territories of Pondicherry, and Lakshadweep, newly found in Telangana. So there are jurisdiction to file the patent application, but examination may carry out throughout the country. What are the documents required for that? Covering letter indicating the list of documents. Again, Form 1, Form 2 in detail. Form 3, same technology for filing the foreign country. Form 5 to add your project partner's name. Again, Form 18, request for examination. If DD are checked, then you can give us, we will pay for that. So this is the requirement for patent filing. Fees is given in the website, that is 1,600 for natural person, 8,000 for others, up to 30 pages. Per page, per claim, fees increases. So you can check with the website and you can file the patent by knowing your how many pages and how many claims to filing the patent application. Request for examination 4,000 for individual, 20,000 for the others. Again, Form 9 if you want to early publication. If you want expert examination within 1 year, if you want to get the patent, you are supposed to file Form 18A. The persons who are filing PCT application, if they are choosing India as an ISC or IPA, they can, or applicant is startup, or as per 2019 rule, one of the applicant in your group is ladies or government organization and institute also file. The fees is 8,000 for individual, 60,000 for the others. You can check your website if you want to know about the patents. Click here, designs, trademark, GI, and training center. If you want to file online, comprehensive e-filing, click here, patent, design, trademark will come. Then fill patent application by, you should have e-signature or digital. If you are filing design application, you should have design application, you should have e-signature or digital. Again, for trademark, you should have digital signature or e-signature. Then only you can file online. If you want to file copyright, please go here, open the site, fill the form, upload document. While creating login password like train booking, you have to create your own ID password, log in into copyright office, check the status of your application, and if you are not granted, you can approach to them also. But 30 days is the waiting period to get the copyright for your work. So this is all about the patent, design, trademark, and copyright. If you want to ask any question, most welcome. Thank you.